Hi everyone and welcome to Connected with Latham, where we discuss ideas, legal developments and business trends shaping the global economy. My name is David Walker and I'm a private equity partner in the London office of Latham. In this episode, we're going to turn to the UK CMA's increased focus on PE roll-up transactions. Recent significant investigations, along with similar concerns voiced by other regulators around the world, should spur private equity firms to consider a heightened threat of enforcement action in the M&A space. I'm delighted to be joined today by Ludmilla Le Grand, a counsel in our London office. Luda assists clients with EU and UK competition law and regulatory issues, and her practice spans multiple industry sectors, including energy, life sciences, telecoms, transport, and financial services. Her insights will, I am absolutely sure, be incredibly helpful in today's discussion as we dive into the CMA's recent focus on roll-up deals. Luda, welcome to the pod.
Thrilled to be here, David.
So the CMA has increasingly raised competition concerns about private equity buy and build transactions, including deals that completed some time ago. And it's doing this, as I understand it, to protect against a perceived threats to consumers. What trends have caught the CMA's attention?
Thanks, David. So far, the CMA's focus has been on the veterinary sector. Over the past year, has launched significant investigations into two sets of transactions, which had already completed, including and involving the acquisition of multiple vet practices across England, Wales, and Northern Ireland. Whereas there are a range of outcomes between the two different investigations, one commonality is that in both cases, the CMA essentially unwound these completed acquisitions, which had closed in September 2021 and September 2022, respectively. Whilst the CMA's focus has been on the veterinary sector to date, other sectors that could also be subject to consolidation business models could also come into focus. So elderly care, fertility, dentistry, and physiotherapy come to mind. It's also important to know that other regulators, including in the EU and in the US, have voiced similar concerns. So it is not only the CMA looking at this, and they flag that PE and roll-up strategies are an enforcement priority. As an example, the US Federal Trade Commission brought an antitrust lawsuit challenging an acquisition by a PE firm of several anesthesiology practices in Texas. And the FTC's complaint there seeks what they've called structural relief, so very similar to what the CMA has done in terms of unwinding closed transactions. So overall, PE firms and portfolio companies really need to consider this heightened risk and the growing threat of enforcement, both in the UK, the EU, and in the US when they're thinking about their PE strategies and executions of deals.
So it seems absolutely clear that roll-up deals have landed on the CMA's radar. I mean, I've got two follow-up questions. One is, what transactions would trigger a review by the CMA? And then secondly, what steps can private equity sponsors take to minimize the likelihood of any such review?
Thanks, David. Those are excellent questions. I'll start off by saying that the UK is a voluntary merger control regime, but that it has incredibly broad powers of discretion when asserting jurisdictions to review deals, whether closed or not. A review can happen if a target has 70 million or more of turnover in the UK, or if the parties' combined shares of supply are above 25% in a substantial part of the UK. Now, there's two key points on that second limb that are worth noting. A substantial part of the UK has been previously defined by the CMA as including incredibly narrow geographical catchment areas. So if they want to look at very narrow geographical areas to get to 25%, they can. And it also includes the PE company's entire portfolio. So even if you have two different portfolio companies that overlap, that are held by different funds, they are all in scope when looking at whether or not that 25% market share threshold is met.
So can I just cut in there and ask you that what powers does the CMA have to call in deals that have already completed?
Yeah, so where a deal is not notified to the CMA has up to 4 months from the merger's completed date or from when material facts were known about the transaction, and it will always go for the latter of the two. And the CMA has increasingly noted that it needs sufficient information on what material facts were known at the time to kickstart that 4-month process. So in a recent one of the veterinary deals we were just discussing, the CMA found that the wording used in a press release was not sufficiently clear, and therefore their 4-month clock had not started running.
And how does an investigation into a roll-up deal by the CMA impact buyers?
Yeah, that's another really good point. So when you assess a deal, you look at what the PE fund and the portfolio companies it has at that point in time. If that PE fund then goes on and acquires several targets in the same industry, if and when the regulator looks at it, it will look at the present facts when that investigation is started. So the assessment that could have been done at the time, where you potentially only had 1 or 2 overlapping portfolio companies, by the time the regulator goes to look at it, it will look at the entirety of the acquisitions as and when that investigation is started. It's also worth noting that the CMA has incredibly broad powers, and we refer to them as initial enforcement orders, that are imposed in all completed transactions and sometimes in anticipated deals. And this is done based on a standard template that the CMA does not deviate from. And these IEOs, as we colloquially call them, require the merging parties to hold separate and prevent any material changes to the businesses being acquired, unless you get CMA permission, which is onerous and difficult to do. Equally, under the IEOs, the CMA can require a monitoring trustee to be appointed, and they act essentially as a hold separate manager, which prevent the parties from further integrating the transactions that are taking place.
And how do these enforcement orders impact private equity buyers?
So that's a really good point. They're incredibly disruptive specifically for PE buyers because the hold separate order, the IEO, is imposed on the entirety of the PE group. So you essentially have a hold separate order that touches on every single portfolio company of the group, even if they're not in scope for the specific investigation. And also breaching an IEO can result in fines of up to 5% of the global revenues of the entire acquiring group. So not just the portfolio companies that may overlap with the target. So there, thinking about all of that in the round, PE sponsors should really be seeking certainty and employing risk mitigation strategies when engaging or thinking about engaging with the CMA. And that could be in the form, where appropriate, of a briefing paper where you tell the CMA in a short submission that the transaction does not lead to concern and it kicks off that 4-month period, or in some circumstances, a full filing may be more appropriate.
If I had my life again, I think I'd want to come back as an antitrust lawyer. It seems an absolutely fascinating environment for antitrust and regulatory lawyers at the moment, with the CMA flexing its muscle in terms of enforcement powers in the context of private equity deals, and also other regulators taking a similar view in other jurisdictions. So it's a time where private equity sponsors need to be really proactive in their approach to manage the merger control risk at the very outset of deals, and then to try and navigate through that difficult enforcement landscape. Thanks so much for joining me today, Luda. This has been absolutely fascinating.
It's been fantastic. A real pleasure to talk to you today, David. Thank you for your time.
So thanks everyone for listening to this episode of Connected with Latham. You can subscribe and listen to new and archived episodes of Latham's podcasts on lw.com, Apple Podcasts, Google Podcasts, Spotify, or indeed wherever else you get your podcasts. If you'd like more information about the topics in this podcast, please email us from the links located in the show description. We hope you'll join us again next time. Bye.
This podcast is provided as a service of Latham & Watkins LLP. Listening to this podcast does not create an attorney-client relationship between you and Latham & Watkins LLP, and you should not send confidential information to Latham & Watkins LLP. While we make every effort to assure that the content of this podcast is accurate, comprehensive, and current, we do not warrant or guarantee any of those things. And you may not rely on this podcast as a substitute for legal research and/or consulting a qualified attorney. Listening to this podcast is not a substitute for engaging a lawyer to advise you on your individual needs. Should you require legal advice on the issues covered in this podcast, please consult a qualified attorney. Under New York's Code of Professional Responsibility, portions of this communication contain attorney advertising. Prior results do not guarantee a similar outcome. Results depend upon a variety of factors unique to each representation. Please direct all inquiries regarding the conduct of Latham & Watkins attorneys under the New York's disciplinary rules to Latham & Watkins, LLP, 1271 Avenue of the Americas, New York, New York, 10020. Phone number 1-212-906-1200.